I was just reflecting when I was listening to both Martin and Ishmael. I said to myself, if I step out of your studio today, break the law, I appear before a magistrate or a judge and I'm found culpable, can I claim immunity? And I'm, of course, I'm kind of stretching the parameters a little bit, but it sometimes is important to use something as simple as that. Just say, can I claim immunity? And say, it's because I am Jerotich Seii, a citizen of the Republic. And for these reasons, I need immunity, etc., etc. And I can make a long argument. Someone say, no, just because you're a citizen of the Republic does not make you immune from prosecution if you do the following things. And as a citizen, I can initiate a popular initiative. Okay, so then you come to the head of state, who, in my opinion, is cherry picking, because the head of state, on the one hand, wants to be immune from prosecution, so that whatever he or she chooses to do during their tenure, in the best interest of the country, ostensibly, cannot be challenged in a court of law, and he or she cannot be sued and cannot be prosecuted while in office for that action. So they want that kind of immunity, but they also want to behave like Raia, like me. So I feel we cannot cherry pick. The president cannot wake up today, I'm just a mwananchi like Jerotich and I should be able to drive a popular initiative. No, you can't sue me. And you cannot prosecute me while I'm in office. So where does it stop? This is the imperial presidency that we should really guard against. But back to my position. As petitioner number 2, in the basic structure section of the petition, and also as a co-convener of Linda Katiba, from the beginning, I have been unequivocal about the fact that this entire process has been a Trojan horse. This has not been about Kenya for posterity, but about the rearrangement of political interests to suit an elite, the same elite that apparently seems to have been excluded from this process. What I saw was a process that would allow a certain section of the political class to spread power amongst themselves. I always say, whether I work on my energy justice issues or Linda Katiba issues, where is Wanjiko in all of this? Why are we always, even when we talk about amendments, focusing on the very top and not what the citizens of the Republic require? Article 43, our economic and social rights. Now, coming to the issue for me of where the Supreme Court needs to pronounce itself, I feel that at the end of the day, having heard the 12 judges of the superior courts be very clear, whether we want to dismiss what they said as serious, not serious, political, not political, for me, it is the responsibility of the Supreme Court of the Republic of Kenya to be unambiguous and to look at issues for posterity, not to suit the political tone or feeling of the moment and of the day, which is where I feel as Kenyans we conflate these matters. And if the Supreme Court, like I said, wants to engage in nuanced political interpretations of legal issues, then it might as well be us guys over here sitting here, and then we will determine, because we'll infuse a bit of the law, we'll infuse a little bit of society, we'll infuse a little bit of politics, and eventually come up with something that we need a Supreme Court that gives us the parameters on these threshold issues. And when it comes to amendments, I have never been against amendment of a constitution. You can amend something, especially when something is not fit for purpose. But the basic structure doctrine is talking about the difference between an amendment and a sheer alteration. And the BBI amendment bill was akin to repealing the Constitution. When you look at the dozens of issues that were raised, and the judges of the superior courts already pronounced themselves on this issue, and they said, look, you cannot introduce multiple issues. It cannot be an omnibus. You cannot bring 78 questions to be discussed and answered, and you answer to the bill in a referendum, yes or no. These are the things where we need clarity as the citizens of this republic. When does amendment become an alteration, become a repeal, become a destruction of the Constitution as we know it? If you want to amend something, by all means, use the correct process, but do not hide behind handshakes, behind task forces, behind amendment bills to say, oh, we are just benignly amending a couple of things because this Constitution is not fit for purpose. If you read the amendment bill, it was a repeal. And if you want to repeal, we go back to the drawing board. We go back to Wanjiko. We go back to the people of Kenya and say that 2010 Constitution was not fit for purpose, is not fit for purpose. What say you? And can we start again? Instead of backdooring all of these things. And that is why you have 80 petitioners that took this matter, not for jokes and to waste the court's time and to abuse office, but to say these are threshold matters that we need all the courts, and I'm glad it got to the Supreme Court, to pronounce themselves on, to render judgment so that we stand guided as the citizens of this republic.
I think when all is said and done,
yeah.
so when all is